Good afternoon, everyone.
Good afternoon. Good afternoon, and welcome to the First District Court of Appeals. We have one case on the docket this afternoon, and that is Dansbury versus Mercy Health. Mr. Dahl is here on behalf of appellant. Mr. Sweeten is here on behalf of appellee. Mr. Dahl, you will have 14 minutes to argue today. Would you like to reserve any of that time for rebuttal?
No, thank you, Your Honor.
All right, you may begin, and I will keep your time.
Thank you, Your Honor. May it please the court, opposing counsel. I'm here today representing Wanda Dansbury on her appeal. Plaintiff's appellant's first assignment of error was that it was improper for the court to deny plaintiff's 56F motion for additional time to respond to the summary judgment filed by defendant appellee. During the entire litigation at the lower court, Mercy was obstructionist in how they handled the case. They refused to provide information. They filed for summary judgment with no less than 3 pending sets of discovery that were not answered.
Mr. Dahl, can I ask you a question? Why didn't you, or did you, notice a corporate rep deposition and get a Mercy employee under oath who has to research and figure out the answer to this, to answer your questions about who this individual was?
I agree, Your Honor. And what I had done is really I had requested the discovery because who I was interested in talking to was who had transported my client that day when the incident happened. I wanted to know who that person was and find out what they'd said, because I thought that was the most relevant query to be answered was, hey, who was transporting her? What were their qualifications? What was their relationship to Mercy, either Mercy Hospital or Mercy West Park at the time? So we had not done that. We had pending discovery requests that had not been answered. And typically move on to depositions. I'd like to get the written discovery done. And the written discovery was withheld until the summary judgment was filed. So we had not gotten to that point, prior to the summary judgment being filed, and then plaintiff moved on to trying to respond to that as best as we could while moving for a motion to compel the discovery responses, which brings us to the next point, that once that discovery was compelled by the court, and it was compelled, Mercy then responded and named 16 individuals who were authorized to transport patients without providing any context as to what there was to Mercy, what their training, their expertise was, or who even actually did it. Just 16 names of everyone who was quote unquote authorized. Which brings me to the first important case, which is Conkin v. CHS Ohio Valley, Inc., which was decided by the First District Court of Appeals, where it was determined that it must be determined that whether the use of the equipment required some amount of professional skill. Well, without knowing who this person is or anything about them whatsoever, that determination can't be made by anyone.
So in the list of the 16 names, did they never indicated that someone on that list actually did transport her, did they?
No, they just simply said these were the people that were authorized to transport patients during the month when Miss Dansbury was injured.
Did you ask for, and did they provide employment records so that you could match the time? Maybe they had a duty to do it themselves, but if they didn't, provide employment records so you could match who would have been working during that time?
When plaintiff's requests for employment files were sent, the response from Mercy Hospital was not applicable.
Well, so they just gave you 16 names of people who worked during the month, but not even during that hour?
Exactly. They didn't just specify who was on duty, when it happened. They didn't give me any information or context whatsoever.
Did the court order them to do so?
The court ordered them to respond to the discovery that plaintiff had asked, and part of that was employment files, and it just wasn't provided. The term was not applicable, which is why the subsequent 56F motion saying, hey, if they haven't provided anything that we've requested, I need to depose all 16 of these people and find out who was there.
So let me make sure I understand the timing. You file a motion to compel. Court grants that motion to compel, orders them to produce additional discovery, and the motion for summary judgment is pending. You don't get the answers that you think you're entitled to, so then you file your 56F. Is that fair, or did I mischaracterize that?
That's correct, Your Honor.
Okay.
And then that motion was denied and they ruled on the summary judgment. Although I think it's important to point out in the court's order compelling Mercy to comply with discovery, it stated specifically that they believe the identity of the person transporting Ms. Stansberry to be significant. And that question was never answered. And then the court goes on to rule essentially contrary to their previous order and just granted the summary judgment motion without finding out that information.
Did they say they didn't know, or did they just never give it to you and maybe ignored the court orders to provide it?
It's a little unclear if you go back through the responses. It seems like the response indicated to me that they didn't quite know who was transporting her if I was to read them. But, then they answered with everybody that was authorized to transport patients during that month. So it's unclear to me whether they actually know or not. And I don't feel like I ever got sufficient answers to these questions before the summary judgment was ruled on.
Did you ask for and did they provide any accident summary reports that would have listed who was driving? I mean, I think surely they would have had that. We
requested any and all incidents or anything like that was related to the accident. There was nothing propounded that indicated there was any type of accident report or report being made. And if you read my client's deposition testimony, essentially whoever was transporting her essentially bandaged her foot and drops her off back at Mercy Health West Park and then leaves, and nothing's ever known until Ms. Stansberry's mother comes back from being out of town for a couple of days and sends her, "Hey, my mother is complaining of pain. What's going on? What are you going?" She says she's really hurting. Why aren't you helping her? They send her back to the foot doctor who unwraps it. She has an open fracture. So I wouldn't believe there would be any incident report because I don't think that anybody bothered to look into her at all when she came back from getting her foot injured. For days, she sat at Mercy Health West Park with an open fracture. Which brings me, Your Honor, back to the Conk v. CHS point, is that this professional conduct is a very important part of the claim. Without showing that there was professional expertise or conduct required, it can't be a medical claim. And we just don't know that information here. So for the court to then rule that it is a medical claim, I think is a premature ruling. Or in the alternative, if the court does not want to permit discovery on that issue, then they have to hold that it's a negligence claim because Mercy Health West Park can't show that it was a medical claim. And
if it's a negligence claim, if it's a negligence claim and not a medical claim because it was a third party involved, would that be a claim against Mercy? Or would it be against the third party?
I would believe it would most likely be against a third party if there's a valid independent contractor who has a contract to do work for Mercy as far as transporting patients. Then I believe, yes, there's a party missing.
And your position is even if it's a Mercy employee, it might not be a medical claim because you just weren't able to discover enough information to make that determination, for the court to make that determination.
Correct, Your Honor. I think there has to be some showing that this was somebody other than just Joe Bag of Donuts with a driver's license running patients from Mercy Health West Park to Mercy Hospital. As far as did they have any patient training? Did they have any training, any type of medical training whatsoever? Not even necessarily a nurse and RN training, but any type of training whatsoever. When you go to the Hill v. Wadsworth case, they specifically said there that they had a volunteer who was set to do pushing a patient around in a wheelchair. And because this task had been assigned to a volunteer, it was basically a de facto ruling that there was no professional expertise required because the volunteer was doing the work. Likewise here, if this is just some guy who has no medical affiliation whatsoever, who's basically loading people up in vans back and forth between hospitals, that doesn't necessarily mean there was any professional expertise required to do that. And I don't believe that you can find that that's a medical malpractice claim or a medical claim at all. And I do believe
you've got you have about 6 minutes left if you'd like to use them all now.
I would, Your Honor. Thank you. And I do believe that this case here does specifically mirror a lot more the Hill v. Wadsworth case, where a volunteer had originally been tasked with pushing somebody around, even though it wound up eventually being a hospital employee that was pushing her. They still found that to be found that to not be a medical claim. And just in this case, I think it's the same thing. Some person was pushing Miss Dansbury. Of course, we don't know who that was at this point. And then a really bad injury took place as a result. And I think to determine that that was a medical claim was done extremely prematurely by the trial court.
So your theory of a medical claim is that if I'm a janitor at Mercy and I see someone who's in pain at the hospital and I take it upon myself to help that person by bandaging them or providing CPR or whatever, that wouldn't constitute a medical claim because I'm not actually trained to provide medical support in those circumstances.
Correct, Your Honor. I think that's defining medical claim far too broadly. And that's offering entirely way too much protection for these giant for-profit entities that, quite honestly, nearly have a monopoly on medical care in Cincinnati area. The CEO of Mercy Hospital made over $3 million last year. Giving that kind of mega protection to this entity seems to be going well over the top from what they should be entitled to, especially given that Browning v. Burt states that this medical claim should be defined more in a more narrowly than that. And further, in the Southern District of Ohio, in Price v. I apologize. In Price v. United States, the court held that these medical claims shouldn't just be things that can happen anywhere, that just happen to a hospital. There should be some relation to medical care. Exactly in the seminal case from the Supreme Court of Ohio, the Rome case, they didn't determine that being pushed around in a wheelchair is a medical claim. They said being prepped for x-rays, and when he fell on the way to his x-rays, that was medical care because it was done with some professional care by an employee of the hospital. Those are all things that we don't check here. Miss Dansbury was being transported to treatment for a foot injury that had nothing to do with her wheelchair. Her wheelchair was being used as a result of her injury from a stroke that she had suffered that she was going through physical therapy for at Mercy Health West Park. Her foot injury was an abrasion that didn't affect her ability to ambulate whatsoever. That was the stroke. So the medical care she was receiving that day had no relation to her wheelchair. So the fact that, the wheelchair actually was not related to her treatment that day. And then as a result, she winds up having this grievous injury that's going to impact her for the rest of her life. And she's looking for help from the courts that so far she hasn't got. And that's all I have, Your Honors. Thank you.
All right, and you will have 2 minutes if you choose to use it at the end.
Thank you, Your Honor.
Mr. Sweeten, you have 15 minutes.
Thank you, Your Honor. My name is John Sweeten, and I represent the Appalese, Mercy Health West Park, and Mercy Franciscan Senior Health Housing Services, Inc. I will probably refer to them as just Mercy throughout the argument. What Mr. Dahl failed to do is to kind of lay out the factual background for the court.
Well, let me ask you this on the factual background. Can you answer on the state of the record unequivocally whether the individual that they're talking about was a Mercy employee or not?
The individual identified in plaintiff's deposition?
Correct.
Yes, they identified someone by the name of Brian, and we, in our list of 16 authorized drivers in August of 2018, there was a Brian Henderson that is listed as one of the approved drivers.
I realize that he's listed. My question is he the one who transported her?
We do not know who transported Miss Dansbury on August 2nd of 2018. And that,
you mean Mercy Health has no records that would allow it to determine who transported one of its patients on a particular date?
It does have records that show transportation on certain dates, but on this date, on August 2nd, there's no indication of anyone transporting Miss Dansbury from the facility.
Do you deny that she was transported?
No, we do not deny that.
Well, I mean,
How do you
isn't,
know it's an employee then? How do you know it's not a third party? If Mercy doesn't have records that she was transported,
We stated in the first set of interrogatory responses that our record showed it wasn't a third party provider. There is a relationship with an outside company, but they weren't listed as driving any individuals on that date.
well,
So
I'm
that's-
sorry, what, you just said there weren't any records about the incident. So what records are you talking about?
Well, there would be, I believe that there are sheets that show transportation on various dates.
and
In
did you
around.
produce those? Did you produce those?
I believe, I can't remember if we did. I would think.
I guess, Mr. Sweeten, look, our concern is that the plaintiff asked you, your client, in 17 different ways, who the identity of this person was. And as I read the interrogatory responses, you all did not answer that with any sort of precision. There were efforts to avoid the question, references back to other answers that were non-answers. And I mean, at the end of the day, they're entitled to know who the person was transporting this individual. And I just think it's a problem for you all if you can't answer that question.
We don't, I mean, we do not know who transported.
But you
Ms.
didn't
Danbury
say
on
that
that
in the answers to the interrogatories. You never said, we don't know.
Well, we
You
did.
said, the first question, or one at least referred to in the brief, was if she was transported. They just asked, as a matter of fact, was she transported? And you said that question was vague, ambiguous, and confusing. And I'm not going to put you on the spot to tell me how it was vague or how it was ambiguous or how it was confusing. But then you said, without waiving that objection, you said it's Mercy's understanding that she was taken there and that she had to leave. That doesn't say we don't know anything. It says our understanding is she was. And then they asked who transported her. And again, that's all they asked, who transported her. And you said it was vague and ambiguous and confusing. Again, I'm not going to ask you to articulate how it was vague and ambiguous and confusing, but you say you rely on the previous interrogatory. And then you say subject to and without waiving the objections, unknown. Unknown what? Unknown who transported her? Is that what you're saying? And I guess now hearing you argue, maybe that is what you were saying. Mercy does not know who transported her.
We do not know. And if interrogatory 3 in the second set of interrogatories that we answered, it was asked, please state who transported Miss Dansbury to Mercy Hospital to her wound care clinic appointment. And our answer was unknown.
Okay.
So it could have been a third party, not a Mercy employee.
Exactly. We don't believe it was a third party transportation company. It could have been a family friend. It could have been a family member, but we don't.
Well, I think what's difficult based on what you're telling us is the trial court relied on the premise that it was an employee of Mercy, because the court says what is now clear is the individual was an employee of Mercy. And I guess that's just wrong, isn't it?
That was the court's interpretation of the discovery responses and what was provided to it. Yes. I mean, we did not explicitly say that the transporter of Miss Dansbury was a Mercy employee. I think the court was making that assumption, and I think in the trial court's eyes, the identity of the transportation driver was irrelevant, because then you get to the legal question of, was the activity a medical claim? And it's not disputed that Miss Dansbury had pressure sores on her foot. She had those in the hospital before she got to the West Park facility. She fell and fractured her
But
hip.
so if it's not a hospital employee, but not a Mercy employee, but a third party, then it's not a medical claim, right?
That's good. I would say that that's correct, but
And
yes.
so then they would be within the statute of limitations.
But it would be against a mercy defendant, I believe.
Right.
Yes, because the statute of limitations for a negligence claim is 2 years and for a medical claim is 1 year.
And the judge found that this was a mercy employee because I guess the judge somehow read in the deposition that she said that the person that transported her had a mercy logo, a shirt with a mercy logo on it.
Yes, that was the testimony.
That wasn't the testimony. She didn't say that.
Do you know where that is in the deposition? Because we couldn't find it.
She testifies that the individual had the name Brian on his shirt, but I mean, I read the deposition a couple times and I don't see anywhere in there where she said that during that testimony that mercy was emblazoned on his shirt somewhere.
Yeah, Your Honor, I don't know if it's in her deposition or if it's in Chelsea Dansbury's deposition, which was her daughter.
But you're telling us in there is in somebody's deposition, there was testimony that the Brian was wearing a mercy shirt.
I do recall that, and I think there was testimony that he had driven her on prior occasions too, so they were familiar with this individual. This wasn't just a one-off where they had just first time they'd ever seen this individual.
Well, let me follow up on that then, because I'm puzzled by the state of discovery in this case and the answers to the interrogatories. Accepting that Mercy does not know who the driver was, are you also saying that it was unknowable, that with that information given to you by discovery from the plaintiff and the work records and everything else in the business records of Mercy, that Mercy was unable to confirm it was this Brian person? I mean, I assume they would have talked to him and if he was still employed or tracked him down if he wasn't. Are you saying that despite all of that, Mercy to this day can't figure out, it's unknowable who was transporting her?
Yes, Your Honor. The investigation was done with respect to Brian, linked it up with Brian Henderson. Their description of him in the depositions matched his physical appearance and description. And with speaking, there are no records or his recollection indicating that he transported Miss Dansbury on the day in question.
Thank you. And you've got about 5 minutes left.
Okay, so I think I'd like to direct the court's attention and analysis to what is a medical claim. So I think there's two cases that the court should consider: the Rome case and Conkin, which Mr. Dahl discussed. I think the court's probably familiar with the Rome versus Flower Memorial Hospital case. That's a Supreme Court case from 1994, Ohio Supreme Court case. And that dealt with the issue of whether a medical claim includes a claim for a hospital's negligent use of hospital equipment when caring for a patient. And there were two cases in Rome. One was Miss Rome and falling off an x-ray table. And the second case was involved a Mr. Eager that had a knee surgery, and he had physical therapy at the hospital. He was being transported to and from physical therapy in a wheelchair on his way back from physical therapy. Wheelchair malfunctioned, broke, and he was injured. And the court in both cases there said that these were medical claims because there was hospital equipment used, and that these were ancillary and an inherent necessary part of each of the patient's ongoing care, treatment, and recovery.
Well, let me ask you the question I asked Mr. Dahl slightly differently, which is, if the issue is not like the wheelchair malfunctioning, but the issue is Brian or whoever it was essentially performed malpractice on her by treating her for this injury improperly because, you know, he wasn't a medically trained person, like, does that still fall within the ambit of medical claim under the statute?
I think it does, Your Honor, because if he's negligently transporting her, is not using the wheelchair properly, I think that falls under the statute, under Rome, and the cases that have been decided after Rome that support that transporting a patient falling off a gurney, a security officer improperly placing a patient on a stretcher, a minor child that falls out of a wheelchair because they're not properly restrained. Those are all medical claims that fall under the 1-year statute of limitations, not the 2-year statute of limitations for negligence. That
Does
was
it
the
make
thing.
a difference that those cases all dealt with injuries on site? In other words, they weren't the transportation with it was internal, not external.
I don't think that fact matters. It is a distinguishing fact, but I don't see a difference between in the Rome case where Mr. Eager, if he's being transported intra-hospital for medical care, treatment, therapy, I don't see any difference between leaving our facility, Mercy West, and transporting a patient to off-site for doctor-ordered care. She was following up on a weekly basis for the wound on this pressure sore on her left heel. So while it is different, I don't think it matters. I think it would still fall under the guise of Rome and the cases decided after Rome. The Conkin court that had to deal with a Hoyer lift. This was a lady, Miss Anderson, that was in a nursing home, and she was wheelchair bound. They used a Hoyer lift to assist her with getting into a shower. So the court's analysis there had to look at the nature of the medical equipment. And so they asked, was this Hoyer lift used for prevention or alleviation of a physical or mental defect or illness? The answer was no. Was it part of a medical procedure? No. Did the equipment rise out of any physician-ordered treatment? The answer is no. That's different from our case here in the Dansbury matter, as well as in the Rome case, that the transportation, use of a wheelchair to and from doctor prescribed treatment is ancillary and inherently necessary to, in this case, Miss Dansbury's ongoing care, treatment, and
well, again, let me ask the question slightly differently. But like, let's say I walk into Mercy and I've got a broken arm, and the person that greets me at the door is the janitor, but I think he's a doctor. And he says, let me treat you, and gives me a sling and a bandage and sends me on my way. And then that exacerbates my injury, and I have to have surgery, and it's, all sorts of problems arise from there. Like, does the janitor performing medical work on me improperly constitute a medical claim under the statute?
That's a good question, Your Honor. Different factual scenario from what we have here. I would say the janitor is acting outside the course and scope of his employment, and I think there would be an argument that it wouldn't be a medical claim in that situation.
What about in this case, if when they were being transported, Brian or whoever was driving ran a red light and was negligent, and they were in a car accident, and that's how she suffered the injury to her foot? Would that be a medical claim?
Another good question. And I actually thought of that scenario, but I didn't think through it enough. I did not find that issue in any of the cases in Ohio when doing the research. Would that-
Because the distinction is it the transporting that makes it a medical claim? I mean, what is it? Where along that continuum, what act makes it a medical claim? If the negligence is bad driving.
I think that would be a little bit more tenuous if you ran a red light and caused injury. But in this case here, Ms. Dansberry was finished with her wound care treatment. She was being brought from that facility in the wheelchair, being pulled up the ramp to the transportation van. So I think it's clear that would be a medical claim because of it was assisting her from the facility to the van to get back to Mercy Health West Park. So
It's only a medical claim if it's a Mercy employee. If it's a third party, it's not a medical claim.
I think that's right, Your Honor.
Okay.
Our questions have taken you over your time, but I'm going to allow the panel to ask you any other questions that they have.
Judge, may I just be able to have 30 seconds to distinguish the Hill case?
Yes.
So Hill, Mr. Daub said something that Hill involved a volunteer. I think if the court reads that case, it dealt with the discharge of Ms. Hill from her treatment at the hospital. A nurse wheeled her out in the wheelchair through the lobby out into the parking lot area. At some point, the nurse becomes distracted and Ms. Hill then decides to get up out of the wheelchair to go leave. She falls when she does that. The court found that was not a medical claim because the use of the wheelchair there was not in furtherance of any medical treatment, ongoing care. She was discharged. She caused the injury herself from that point, and she was outside the facility. So there's a distinction there that's important. The Hill case does not support Mr. Dahl's argument, and it's not, the facts are not similar to this case or to the Rome case.
Thank you. And Mr. Dahl, I know you indicated you weren't inclined to use it, but if you want, you have 2 minutes remaining. All right, you're muted, but I think you said no, thank you, Your Honor.
Yeah, sorry, Your Honor. No, thank you. I think I've used all the time that I need. Thank you.
All right. Thank you both very much for your arguments today. We will take this case under submission and we'll give you a timely written opinion. And that will
Thank you, Your Honor. Have a great day.
Thank you both.